In Module 3, we are looking at real property and bankruptcy. This PowerPoint specifically deals with real property. The learning objectives for real property is to understand the scope of real property, rights and interest in real property, acquisition of real property and transfer by sale, and obligations related to property condition and land use. So for the overview, the law of real property concerns the ownership, acquisition, and use of land. That's opposed to personal property, which we discussed in Module 1 under Secure Transactions. So real property includes not only land, but also things firmly attached to or embedded in the land. So it might be building, trees, crops, vegetation, water, groundwater, minerals, which are below the ground, and airspace above. When we get into some of the difficulties of dealing with property, one of those items is fixtures. So a fixture is an item of personal property that has become so attached to or used in conjunction with real property in such a way that it ceases being personal property and becomes part of the real property. But the general rule or law is that fixtures belong to the owner of the real property. The problem comes into play with personal property may be subject to a lien or security interest, which we looked at in Module 1, at the time it is attached to real property. For example, an appliance store takes a security interest in a dishwasher installed in a home and perfects the interest by filing the financing statement in the appropriate real estate records office. So the factors that you have to look at to determine the status as a fixture are attachment, adaptation, and intent. Attachment is really talking about the actual physical attachment to real property is not necessary. For example, if you have heavy machinery or remote control device for automatic garage door, it may be considered a fixture even though they're not physically attached to the real property. Adaptation is dealing, for example, with keys or custom-sized window screens and storm windows. They've been held to be fixtures. And intent is looking at if the owner does not want an attached item to be considered a fixture, he must specifically reserve the right to keep the item. And specifically, which we deal a lot with in businesses, are trade fixtures. And that's an exception to the usual fixture rule. It involves trade fixtures, which are personal property attached to leased premises by a tenant for the purpose of carrying on the trade or business. So it remains the tenant's personal property and may be removed at lease end. So although they are an exception to the general rule, a business would be very wise to specify their trade fixtures as personal property in the commercial lease agreement or risk a dispute over the property at lease termination. So many businesses do not own the building in which they operate in, but they have to bring in various items. Let's say it's showing you the picture of a bakery, so she has to bring in ovens and she has to bring in industrial dishwashers and all the cabinetry and things like that. So some of the items like table and chairs will certainly seem like it would easily be removed. But it is a good idea if you're executing a commercial lease that you specifically identify which items are fixtures owned by the person running the property or the business running the property and the lessee, and which are owned by the lessor, which is the person who owns the building. Now we're talking about ownership in land there are different ways in which you can own or own land. So we're going to start with estates and land, and this term is used to describe a person's ownership interest in real property. So it can be classified as either a freehold or a non-freehold. Freehold estates are ownership interest of uncertain duration. A non-freehold or a leasehold estates are those held by persons who lease real property. And then there's also co-ownership when two or more persons share same property ownership interest. And the most common forms of freehold estates or rights to exclusive possession are fee simple absolute and life estate. A fee simple absolute is the normal concept of full ownership of land. And a life estate gives a person the right to possess and use property for a time measured by his or another person's lifetime. So a fee simple absolute is what you're probably used to. You may or may not have ever owned property, but when a person buys a house or a piece of property and they might sign a mortgage or a deed to secure debt, but their ownership in the land will be fee simple absolute as long as the mortgage is paid. A life estate is basically, let's say that I have a piece of property and I give a life estate to my child for my life. So my child has the ability to use that property as long as I'm alive. But once I die, then that life estate would pass either by my will, or meaning that I executed a will, or by state law. But it also can be a life estate in the person you're giving it to, their life. For example, let's say I have a piece of property and I give a life estate to my brother for his life. So he's able to use that property as long as he lives. Now, if he dies before me, the property would revert back to me. But if he dies after me, then the property would either pass according to my will, and if my will doesn't give it to him, then by state law, or it allows him to pass it by his will, depending on the state that he resides in. And currently there are 7 types of co-ownership recognized in the United States. It's tenancy in common, joint tenancy, tenancy by the entirety, community property, tenancy in partnership, condominium ownership, and cooperative ownership. And we will look at a number of these. Property law is a year-long course in law school, and we're, again, not trying to turn you into attorneys, so I'll try to keep it as simple as I can as we go through all of this. An easement is the right to make certain use of another person's property. That's called an affirmative easement, or to prevent another from making certain uses of his own property, which is a negative easement. And easements may be acquired by grant, reservation, prescription, or implication. So, for example, if you agree to have someone put a billboard on your property, that's an affirmative easement. But let's say the people next to you that own the property next to you want to build a drag strip, and you don't want them to build a drag strip. So they have agreed for, whatever basis, you might pay them money or something like that, that they will not build a drag strip on that property during the time that you owned that property. And again, that's a negative easement. So it keeps them from certain uses of their property. And sometimes these come about as a result of someone doing something that annoys or bothers their neighbor, and then there's actually a court order which states that you can no longer do that. And the judges and the attorneys do try to come up with some type of compromise. For example, my father has a game bird preserve in Texas. It's a licensed game bird preserve, and people also come out and shoot skeet. And sometimes they were doing it late in the evening, and so an adjoining property owner felt like that was too much shooting. So they took it to court, and basically they agreed upon that my father would be allowed to do it between 9 in the morning and 6 o'clock at night, 7 days a week, as part of his business. But he couldn't do it before 9 in the morning, and he couldn't do it after 6 o'clock. Any day of the week, he's not allowed to do that. If he does that, he violates the court order. And it was a settlement as a result of the neighbor filing suit in court. So if we're looking at the different ways that you can acquire an easement, by grant is talking about when an owner of property expressly provides an easement to another while retaining ownership of the property, he is said to grant an easement. An example of that is the billboard. By reservation is when one transfers ownership of her land but retains the right to use it for some specified purpose. She is said to reserve an easement in the land. And that's simply talking about, let's say that a person owns 100 acres and there's a house on the 50 acres that adjoin the road, and there's a small cabin on 50 acres that is in the back of the property. And so the person who owns all of the property splits it into 2 parcels, the front 50 acres with the house and the back 50 acres with the cabin, but there's no road access on the back 50 acres. So she sells the property but gets an easement by reservation that she's allowed to use the road that travels from the cabin out to the private road that goes from the cabin over the property she just sold out to the actual public access road. And that's an easement by reservation. An easement by prescription is an easement created when one person uses another's land openly, continuously, and in a manner adverse to the owner's right for a period of time specified by state statute. So depending on the state, it might be 5 years, it might be 10 years, 15 years. There's really no set amount. The states vary widely in this. So example is, we'll take again the example of that there's 100 acres. There was 100 acres, and at some point in history, that acreage was split with no true easement being granted by reservation or by grant. However, the people who own the back 50 acres has always used that road to get to the public access road. It was never written down. It's not part of any deed. However, it's an easement by prescription. They've been doing it for 20 years and is recognized by state law that they've always been allowed to do it. It's adverse, meaning it's against who the owner is, continuously and in a manner adverse to the owner's rights for a period of time. So, for example, we're going to say they're doing it for 20, 25 years. That would meet every state's prescription requirements. It was open and it was continuous. So they have an easement by prescription. This tends not to come about or become an issue until that person who owns the front 50 acres tries to sell it. And the people say, well, what about these people who are driving over the land? And it's not obvious on the deed that there's an easement, so they basically either have to fix it or just accept that, fix it by meaning grant that easement or just allow it to be an easement by prescription. But they can't cut off those people's access if it's been open and continuous and in a manner adverse to the owner's right. The last way an easement can be acquired is by implication. So sometimes easements are implied by the nature of the transaction rather than created by an express agreement of the parties. These are called easements by implication, and they take either of two forms: easements by prior use and easements by necessity. And this can also be similar to what we were just talking about by prior use, that someone's been using this land in a way. We tend to see this, that someone put up a fence, let's say between two property places, and for whatever reason the fence was put up in the wrong place. And as a result that fence was in the wrong place, one person is actually using another person's property by accident, by error. Occasionally it does happen on purpose. And they do something, they build a pond or something like that, and again it usually comes to light when the property is trying to be sold. And so that's easement by prior use. They've been doing this for 15, 20 years. The pond was built 10 years ago. Nobody expressed any issue with it, and therefore it can become an easement by implication through prior use. And the other situation is the easement by necessity, that when someone sold a property, they blocked access to another property, getting access to a public access road, and they just didn't think about it when they sold the property. Then the person who needs that public access can actually go to the court and get something in the writing, in the property records, which is an easement by necessity, which is the only way that they can get across the land. Now, if it's being negotiated at the time of sale and it doesn't rise by easement by prescription, then that back property owner may be required to pay some money to get that easement. It just depends on the period of time that was involved. Next, we look at profit and license. A profit is the right to enter another's land and remove some product or part of land. An example of that would be like crops. And a license is a temporary right to enter another's land for a specific purpose. So the tenant who planted the cotton crop has a profit. So they paid for the seeds, they planted it, they worked the land, they have the right to go and remove that cotton. And the combine crew, which actually is going in and picking that cotton, and they're going to pay that tenant for getting that cotton, taking it to market, and they have a license to pick that cotton. So that's the difference between those two. Another situation is a restrictive covenant. So real estate owners may create agreements that restrict use of real property called restricted covenants. Covenants run with the land and bind subsequent owners of the property. And the enforceability of covenants depends on the purpose, nature, and scope of restrictions. It shows you a subdivision to the right. Those of you from the Atlanta area are probably very familiar with these types of subdivisions. So what happens is a developer comes along, he develops a subdivision, and he wants all the houses to be between 2,000 square feet and 5,000 square feet. and basically wants the subdivision to have some, I guess, harmony and continuity and homogeneous look to it. So you're not allowed to plant certain plants. You're not allowed to park more than 2 cars in the driveway. You're not allowed to park on the street. Those are all restrictive covenants. You're not allowed to park a trailer. You're not allowed on that lot. You can only build a certain type of house. You're not allowed to put a travel trailer on there, a mobile home on there, that type of thing. So we see these a lot, especially in Georgia, restrictive covenants, and it's really to keep the property prices up, to have homogeneous communities, and in some cases they're very restrictive. Your grass has to be cut a certain way. You can only plant certain types of plant. You're restricted as to what size pool you can put in the backyard, what type of fence, and some of them are a little bit less than that, but that's the idea of a restrictive covenant. Next, we're going to look at the acquisition of real property. So the title to real property may be acquired by purchase, gift, will or inheritance, tax sale, and adverse possession. And remember the difference between will or inheritance. Will is a owner of the property actually wrote out a will. It's properly executed in the state in which he or she resides. They're dead. They're deceased, and so based on that will, the property passes to whomever they specify. Inheritance is where someone did not leave a will, but by state law, the property is passing to someone that they're related to, depending on their situation, whether they're married, they have kids, that type of thing. Adverse possession occurs when a person wrongfully occupies land and acts in open and hostile manner as if he were the owner, and the true owner must take steps within a statutory time limit to eject the possessor from the land or forever lose the right to eject the possessor. We don't see this a lot in the United States. However, since the mortgage crisis in 2008, we had a lot of homes foreclosed, and so you would go into neighborhoods where virtually the houses were either unsold because it was a new development, or many people lost them through foreclosure, and so some homeless people or people who had even lost the home through foreclosure actually adversely possess that property. And depending on the state, if you adversely possess it openly in a hostile manner, as if you were the owner for a period of time, it might be 7 years, 10 years, 15 years, again, it's kind of all over the place, then you have the right to claim ownership in that property. This actually happens a lot more in other countries, such as India and also in Russia, but they have different types of laws regarding this, so we're specifically just looking at the United States. Adverse possession over significant acreage is very rare as of this date. Most disputes today are disputes over a few inches where a neighbor builds a fence that is actually on another's property. And so that's the most common type of adverse possession that we see outside the foreclosure situation that I was just talking about. And that's where someone has, like I just discussed, put their property in the wrong place, and they've been using it openly. The other owner knew that the property or the fence was in the wrong place, that type of thing. And it becomes an issue when the property is getting ready to be sold, or someone wants to do something to the property, and they're actually affecting the property, that part of the property that they're adversely possessing. Okay, so next let's look at the steps for sale and purchase. So number one, you contract with a real estate broker to locate a buyer, and you're not required to use a real estate broker in the United States. But if you do, real estate brokers help you locate a buyer, usually through agents that they license. You negotiate and sign a contract of sale. And we've looked a few times at statute of frauds, and if you remember from your legal environment class, statute of fraud requires writing when the contract involves the sale of real property. So you cannot actually pass real property without something written down for it to be a legal transaction. Then there's arranging for financing of the purchase and other requirements, and that's if you don't have the cash, which most people today do not have the cash to buy their own houses, so they have to get some type of financing in the form of a mortgage, loan, that type of thing. Also, you might need to conduct a survey or acquire title insurance, and the title insurance the company actually goes out and does a title search, which it basically goes back through all of history that it can find on that piece of property and make sure that the title has passed legally up to the point where it's getting ready to pass to you, the buyer. And then if they're able to determine that it has passed legally, then they give a title policy, which is basically an insurance policy, that if anyone were to come back and claim title or ownership in this land in any capacity, that they would pay for the suit, pay for the legal fees, all of that to take care of this lawsuit. Next, we'll look at closing the sale, primarily involving payment of the purchase price and transfer of the deed, and then the recording of the deed. And that's probably the most important part when we look at sale of property. For a valid conveyance of real property, you have to have execution and delivery of a deed. Each state has a very specific way, whether you have to have witness signatures, whether you have to have notarized signatures, whether people are able, who aren't able to write, whether they can put an X on there or not. And we don't see that a lot these days, but that happened quite a bit in the past. And then different states have very different recording statutes. And the recording is the fact that you take the deed to the county in which the property sits, and it's duly recorded. So by duly recording it, it's showing to anyone who is looking in those property records who owns the property, who holds the mortgage on it, what company holds the mortgage on it. Because if it's not paid in cash, then there's going to either be a mortgage filed or recorded against that property. We also call it a deed to secure debt. And that shows that these are the property owners. However, there's a mortgage on this property. That's what a deed to secure debt is. And this is the mortgage holder on this property. So there's different types of statutes regarding who controls. We don't see this as much now, but we have in the past where one person who owns the property has sold it to two different people, and the seller is in the wrong. However, the two people purchasing it are called bona fide purchasers if they had no knowledge of each other. So these statutes, recording statutes, have come about as a result of that. So a res statute says the first grantee who records a deed to a tract of land has superior title. This goes back also, it's similar to what we were looking at, secure transaction. The notice statute, a later grantee of property has superior title if his interest acquired without notice of earlier grantee's claim to the property under an unrecorded deed. Okay, so your buyer number 2, you had no notice that there was a buyer number 1, and buyer number 1 had not recorded his or her deed, and so therefore buyer number 2 gains superior title. So again, it's a race to the courthouse. That's what the word race refers to, as the first person who gets to the courthouse and records the deed, as long as they did not have knowledge of each other to begin with. And you also have states who have what's called a race notice statute, and that's the grantee with priority is the one who both takes his interest without notice of any prior unrecorded claim and records first. So again, buyer number 2 or buyer number 4, that they had no knowledge that there were prior buyers, and they reached the courthouse and recorded the deed first. Okay, so let's look at the different types of deeds. And again, this is generic and will cover all states because states have very specific rules regarding what type of deeds they allowed. So a quitclaim deed conveys whatever title the grantor has at the time he executes the deed, and it contains no warranty of title. So in that case, this person is saying, I'm going to sign a quitclaim deed. I haven't done a title search. I believe that I'm the rightful owner, but whatever ownership interests I have in this real property, I'm signing it over to you. If there's an issue later on that I didn't really have partial or prior ownership, you have no claim against me, because again, there's no warranty of title. You oftentimes see this. Let's say you have a divorce. A man and a woman own a house together. The divorce decree gives the house to the man, and he pays out the ex-wife's interest in that property to her in exchange for she issues a quitclaim deed. So she says, whatever ownership I have in this property, in exchange for my portion of the property, we'll just say the property's worth $100,000 and they own it outright. that he gives her $50,000, and in return she executes a quitclaim deed, which he files in that county. If he doesn't file it, it's not effective towards any other future buyers. And it says that I now own this property in full. But again, it's whatever ownership rights she has. A warranty deed, which is the type of deed that you want if you're buying a piece of property outright, it contains covenants of warranty about the title, and there are general covenants as well as special covenants. So a general warranty deed, under a general warranty deed, the grantor warrants against and agrees to defend against all title defects and encumbrances, which can be an encumbrance is like a lien or an easement, including those that arose before the grantor received her title. So that's the best deed, the strongest deed that you can have, because if anything arises, that person who sold you the property is going to pay for any lawsuits, any legal fees, whatever it takes to defend the new buyer's title. A special warranty deed, the grantor warrants against and agrees to defend against title defects and encumbrances that arose after she acquired the property. If the property conveyed is subject to an encumbrance such as a mortgage, a long-term lease, or an easement, the grantor frequently provides a special warranty deed that contains a provision accepting those specific encumbrances from the warranty. So, for example, she's selling the property, but it's subject to an encumbrance. Well, let's say it's an easement or it's a mortgage. Then she can only give to what she owns, basically her portion of it, but she's going to defend against anything else that arose after that fact. So once she gets the money and she pays off that mortgage, the mortgage company will then record that mortgage is paid in full against that property. And so a special warranty deed can become a general warranty deed by virtue of the fact that that encumbrance no longer exists. Now, they won't issue a different deed for that, but by virtue of the mortgage company recording the deed that it's paid, recording the mortgage is paid in full, it will release that encumbrance on the property. Then you also have what's called grant deeds, and that's where the grantor implicitly represents that he owns the land, but he makes no covenants. And then you have a deed of bargain and sale, which again is the grant deed. So he's not making any covenants or warranties about his ownership. You might think it's similar to a quitclaim deed, but depending on the states, they're either going to have one or the other. In special circumstances, they might have two, might have both of them, but that would be pretty unusual. Okay, so you're buying property. Obviously, you want to assure your title. There are a few methods of doing that. If you get a title opinion that's issued by an attorney, where they examine the abstract of title and give an opinion about whether the grantor has a marketable title. And in that case, they've gone about and done a title search in the property records. Most property records are now digitized, so it's easy to do these type of title searches. I can remember in law school where we had to go do practice ones for a grade, and they were very difficult because it was all on paper. And so you can be given a marketable title, which is a title free from defects or reasonable doubt about its validity, or an abstract of title is the history of what public records show about the passage of title to and other interest in a parcel of real property, but it's not a guarantee of good title. And someone might be doing some research, let's say, on a piece of property that they're interested in, and they would get an abstract of title from a title company just to determine who might have rights in that piece of property, what issues, what encumbrances, what liens, what mortgages, and that basically allows them to strategize differently about how they want to obtain that property. The best thing that you want is a marketable title, and it's free from defects or reasonable doubt about its validity. And in most cases, when a title company issues a marketable title or a title opinion, it's backed up with title insurance policy. Some states require you to purchase a title insurance policy. Some states do not. Another method is under the Torrens system of registration, and it exists in a few states. One who owns land in fee simple obtains a certificate of title. And this is really left over from common law, from a period of time when people gained ownership of land, not through the passing of deeds between each other. It also sometimes involves, it's an older system of registration that was used prior to us most states converting over to the type of real estate records that we currently hold. And in a number of states, land was given to people if they were willing to go out there and farm it or grow crops on it, put livestock on it, that type of thing. And so they gained ownership through the possession, and this is an adverse possession. The government would put in the newspaper that you could go out and claim this X acres of land. And in some cases it was a specific number, and in some cases you can claim as much land as you can walk across in a day's time, which seems a little ridiculous now, but that's actually how they did it. You can also purchase a policy of title insurance, and that's the preferred and most common means of protecting title. So if you got the title opinion but you didn't get the title insurance, that's not the best that you can get. The title insurance obligates the insurer to reimburse insured for loss if the title proves defective. Okay, so if the title proves defective and there's a lawsuit, they have to defend against it. But let's say that the other party succeeds in the lawsuit and you lost $100,000 worth of investment in this piece of land that you had a title insurance policy on. That title company has to pay you for that loss of $100,000 plus any legal fees, attorney's fees, that type of thing. So you can bet that these title companies are very certain about the title and ownership in this land before they issue the title insurance policy. And then we look at residential property, which has a different set of rules as opposed to just open, what we call raw land or undeveloped land. So in residential property of the last century, we've come up with an implied warranty of habitability. It's developed to guarantee the house is free of hidden defects, rendering it unsafe or unsuitable for human habitation. And it's similar to what in the UCC is called implied warranties for sale of goods. And the seller may be liable for damages if seller breaches the implied warranty. And damages are measured by either the cost of repairs or the loss in value of the house. Now, most states have a situation where if you're selling a piece of residential property, you have to verify that it is asbestos free, that it's lead free, that it doesn't have mold, that type of thing. It depends on the state how much you have to warranty against. And in some cases, you have to sign it and then in the event sign these various documents before you put it up for sale. And then in the event, that's the implied warranty of habitability. Let's say that they do find lead paint or they do find radon or asbestos, whatever you signed off that the house did not have, you're responsible for correcting the problem. If in fact there's damage in which they have to pay to correct the radon problem or get the asbestos out or get rid of the lead paint. Or if there's a loss in value of the house as a result of it, let's say the house goes from $300,000 to $250,000 because of this problem, then you have to reimburse them the value of that loss. And then there's premises liability, and it really refers to negligence cases in which property owners or possessors, such as a business operators leasing commercial real estate, are held liable to persons injured while on the property. So if we look at it in terms of negligence, failure to exercise reasonable care to keep the property reasonably safe, and it generally includes a duty to take reasonable security precautions to protect persons lawfully on premises from foreseeable, wrongful, including criminal acts by third parties. And these cases include the typical slip and fall cases as well as the cases in which an invitee is attacked and injured. So if someone slips and falls and you're leasing that property, they will go after the company that's leasing the property, and they most likely will go after the property owner. And there might be in the lease agreement between the business lessee and the owner of the property that if anything were to happen as a result of this, the leasing company will be responsible for any and all lawsuits associated with that. So even though they sue the business owner as well, the property owner as well as the person who has the business that's leasing it, the lessee, the person who's leasing it, is responsible for any and all lawsuits and any claims or injuries that come about as a result of it. Land use control, one of the items that you look at is nuisance, and that society imposes duties on landowners by nuisance zoning and eminent domain laws. Nuisance refers to the lawsuit that may be filed if a property use unreasonably interferes with another person's ability to use or enjoy her own property. So the situation which I talked about earlier, where my dad had a game bird preserve, or still has a game bird preserve, but he also had a skeet area, and the people filed a nuisance lawsuit against him. You also have this situation where, let's say you have a housing subdivision and someone's running a chicken farm or a dairy farm next to it, and there are some strong odors that waft over into the subdivision. The thing that the courts will look at is, was this nuisance in operation when these people bought this property? And if it was in operation, let's say the chicken farm was already there, then the court will not enjoin the chicken farm. It won't shut it down. It won't tell them they have to get rid of the chickens, because the people should have been on notice that that chicken farm existed. The nuisance situation really comes in is where you're owning and enjoying your property, and someone next to you comes in and does something that creates a nuisance. So it's after the fact. Another land use control is eminent domain. And the Fifth Amendment to the Constitution guarantees that private property shall not be taken for public use without just compensation. And this implies the government's power of eminent domain to effect the taking. The key is the just compensation. What determines just compensation? We're not going to go over the case law involving that. However, your discussion for this module does involve eminent domain. And so you might want to take a little closer look at that. Land use control. The other one is zoning, and you're probably familiar with that, where it's residential zoning, mixed use zoning, business. So zoning ordinances divide a city or town into various districts and specify or limit the uses to which property in those districts may be put. So single family or high density residential uses, or commercial light industry or heavy industry uses. They also put restrictions on building height, building footprint, which is the area that the building occupies on the ground, and distance. Buildings must be from lot lines, like setback regulations. If you've ever spent any time in Hilton Head, South Carolina, you notice there are no signs up in the air, whether it's a McDonald's or a Walmart or a Target. The signs are on the ground, and they're limited to how big those signs can be, and that's an example of a restriction, a zoning restriction, that Hilton Head has instituted to try to protect what the area looks like. Also, zoning ordinances are prospective, thus the ordinance may require gradual phasing out of non-conforming uses in buildings that do not fit the general zoning plan. So you can't change a zoning ordinance and impact businesses or buildings that are already in effect. So it might say anything built in the future can't have a sign over 20 feet high or 30 feet high, or all signs have to be put on the ground. But anything that existing before the fact cannot be affected by that zoning ordinance. And property owners may seek a variance allowing a deviation from the zoning law. So again, it's not retroactive, it's prospective. However, property owners may, let's say they're on the outskirts of an area, and based on the way the property is shaped, or because there's a wetlands involved, or there's a creek running through the property, that they have to change how they put their building, and their building footprint would be in violation of the zoning, because they have to have a 30-foot setback, and because of the creek and the building that they're wanting to use, they got to have a 25-foot setback. So they would ask for a variance to allow them to build at 25 feet. It may or may not be granted. It usually has to go to a city or county council, and they vote on that. Some cities, especially really big ones, have zoning departments that deal with this on a regular basis. Okay, so last, we're also looking at regulatory takings, and that's where the litigation centers around the land use regulations that make the use of the property less profitable for development, and landowners challenge the application of regulations. And the case law, example that they're giving you is Lingle versus Chevron USA. Excuse me. And this is where the state of Hawaii passed a law that capped rental income, that capped what they could sell gas at, because the gas prices were going too high and the citizens were being negatively impacted. And Chevron said that constituted a taking, and it was in violation of the 5th and 14th Amendments of the Constitution. Now, Chevron didn't own these gas stations, but they in fact sold gasoline to these various gas stations that were impacted. So they won the first case in the district court, which was the trial court. It went on appeal. It was reversed at the appellate court and remanded back again to the district court to make a decision. The district court then again found for Chevron. It was again appealed by Hawaii. It went on to the Supreme Court, and the Supreme Court said that it wasn't a taking. Basically, Chevron's attorneys made some tactical errors here, and they probably got fired very quickly after it because they appealed under that it was a taking. However, they argued the situation at the Supreme Court that it was arbitrary and irrational, and it was just against Chevron, and the court couldn't find any indication that it was only impacting Chevron, or the law was passed, the state statute was passed specifically to impact Chevron. It basically impacted anybody who was selling gas on the island or in Hawaii, in any of the islands. And so they lost the appeal. And again, whether they would have won it if their attorneys had handled the appeal correctly remains to be seen, because once the Supreme Court decides it, you can't go back again. So that concludes this PowerPoint. You can look also at the bankruptcy PowerPoint, and then there will be a separate narrated PowerPoint for the problems and explanations. Thank you.